All right, welcome back to The Explainer. Please do send us your thoughts, your questions, your reactions at Citizen TV Kenya, at Yvonne Okwara. Use the hashtag Citizen Explainer, or you can send us a text message. The number is 22422. We're still speaking with the President-elect of the Law Society of Kenya. That's Senior Counsel Charles Kanjama. Thank you for being with us. I'd like us to focus now on contemporary national issues. And first is, governance and the state of the rule of law. And this has been an area of concern for many years, particularly under this administration, as demonstrated by the number of times cases have been lodged in court over government decisions and government projects and the manner in which it chooses to undertake them. And the underlying principle here, even we see in the courts, is the principle of public participation. What do you think about how the government has conducted itself in this respect?
I think there are three main areas where the government has been falling short. One is the issue that you've talked about of governance violations, a failure to comply with constitutional and legal principles when passing laws or policies or trying to implement the law and policies. There have been so many court cases that have established the principles that should guide the executive, the legislature, the devolved units, and any other state organ in matters of law and policy and how to implement them, securing the national values and principles of governance in Article 10 of our Constitution, and that includes a participation of the people as one of them. The second area where the government has been failing is in these very flagrant human rights violations, like illegal abductions, like extrajudicial killings, and other such actions of fighting protesters, attacking the Bill of Rights, which is Chapter 4 of the Constitution, the freedom of assembly, of protest, etc. Misuse by police service of their role to provide security, and interfering with the politicians and the youth, like the Gen Z, when they are manifesting their right to assemble, to protest, and so on. That has been the second major area of serious failure by government. And the third is that over the last 5-6 years, we've noticed gradual attempts to claw back the powers that have been devolved and dispersed in the Constitution to various organs and agencies of the government, the constitutional commissions. We've seen, for example, in the case of the National Police Service, the police want to take the role of the National Police Service. The Ministry of Interior wants to be the one controlling the police. We've seen in the case of the Ministry of Lands, the National Land Commission, they're not exercising their powers effectively. We've seen the constitutional commissions are under-resourced, underfunded. The clawbacks where the executive is interfering in Parliament, where Parliament is not aligning with what the judiciary is interpreting the Constitution as. So these clawbacks, that's the third key area where the government is failing. And the Law Society of Kenya and other well-wishing Kenyans and agencies, we have to put our focus on each of those three areas because they all have to do with the rule of law.
Let's focus a little bit on the issue of public participation. As even has been witnessed with this cooperation deal between the Nairobi County government and the national government, it's currently being challenged in court, again over the issue of public participation. And then we're seeing this sequence of events. A deal is signed at State House, public participation follows, and then the Nairobi County Assembly is then sort of ratifying the deal or giving its stamp of approval. I mean, how should this work anyway? I mean, from a legal standpoint, but even logically, shouldn't public participation come before the fact?
It should come before the document has been signed or ratified. The public participation is to guide the policy makers. Maybe the public participation would have been completely opposed to the project. Maybe it would have given advice on include this, don't include this other issue, give us more information about the financing of this project or this agreement. So definitely public participation under the Constitution, and this is what has been stated by the courts on numerous occasions, should precede the implementation of the policy. It should not be just a rubber stamp. You remember in the 1970s when this famous statement was made that Parliament has just become a rubber stamp of the executive. So this is what might happen to public participation, that it is treated just as cosmetic, window dressing, or rubber stamp. That is not the spirit of the Constitution.
And how should this be done? Because, you know, we're talking about a law. What sort of advice would you give as president of the Law Society of Kenya to, you know, both the public and the government as to how to go about this very critical right in the Constitution?
For the government, they know. And the chief legal advisor of the government, the Attorney General, knows very well, and I'm sure has advised the agencies in government repeatedly. Maybe they don't follow her advice.
Yeah, because I wanted to ask you, now that you've brought in the Attorney General, who is failing when it comes to something as consequential as this cooperation agreement? Is there a place and role for the Attorney General to advise the government before such an action is taken? Is the Office of the Attorney General failing?
The Attorney General has a role in advising the national government. The County Attorney of Nairobi has a role in advising the Nairobi County. But when lawyers give advice, especially when you're an in-house lawyer, sometimes your advice is ignored. And then the question arises, so what do? Do you blow the whistle to the public? And how do you maintain the confidence of your employer while at the same time championing the rule of law? So I don't know what are the facts in this particular case, whether there was an advisory by the Attorney General's office. So I cannot pass judgment on the internal discussions.
But yet we see the Attorney General very present during the signing of that at State House before residents of Nairobi County were even given an opportunity to have a say.
Yes.
And she was right there. So, you know, what does that tell you, even in terms of optics?
For me, what I would say is that there's been a failure by the national government in this issue regarding who in the national government bears the biggest part of the blame. I think we'd need to see what was said by who and when. But definitely the issue of optics is one that the Attorney General has to take into account, because there are various ways of manifesting disapproval when you give advice and it's not followed. And one of those ways is, for example, not showing up in the signing ceremony. So definitely the Attorney General also needs to see how to harmonize both the fact that her office is a legal advisor of the government, and when you give legal advice, sometimes it's even confidential, but also that is a champion of public interest in matters of law. So they have to harmonize those two roles. And it is something which sometimes you do it through optics, as well as sometimes you issue a clear, firm opinion, saying that this needs to be done this way. And if your client, whether it is internal or external client, disregards your opinion, at least your opinion is on the record.
What sort of influence would the Law Society have on the Office of the Attorney General to improve the quality of legal advice that is coming out of the office and legal decisions that are made in government?
The Attorney General, we call her the titular head of the bar. And the president of the Law Society is the actual head of the bar in terms of having been voted by lawyers to lead the Law Society of Kenya. So there has to be collaboration between those two offices, advice, engagement, and that is what I would expect to do, so that we assist the Office of the Attorney General in the same way the Attorney General is assisting the government, because the people working in the Office of Attorney General are lawyers. And whether they are taking out practicing certificate or not, some of them are exempted from taking out practicing certificate. They still are members of the Law Society of Kenya, and they deserve the assistance and also, in some cases, the protection of the Law Society of Kenya, so that they can be effective as they undertake their duties.
All right. Well, we'll come back to some of the many issues that are taking place in the country now, but we cannot ignore geopolitics as we, sit here today. We're in the middle of a very unpredictable position in the world, arising from what we've seen as a crisis in the Middle East, the US-Israeli strikes on Iran and the retaliatory attacks thereafter. The president of the Republic of Kenya condemned the Iranian retaliatory attacks on its Middle East neighbors following that raid by the US and Israel that killed the supreme leader there. And amongst that, and children as well. In your understanding, where does our foreign policy lie in moments such as this?
First of all, I found it to be curious that the condemnation was one-sided when Iran was retaliating against the attacks that were unprovoked by the United States of America and Israel. And I think the whole situation is quite unfortunate. And in foreign policy and matters of diplomacy, you have to, first of all, of course, consider the interests of the country when the country you are representing as you engage in the international arena. Second, you have to consider the international rule of law. What does international law say? Because you cannot just make decisions on the basis of opportunism or based on interest without considering principle. And of course, the principle, as we lawyers who have studied international law know, is under the United Nations Charter. All countries are expected to preserve peace and security, to respect the sovereignty of other nations. So there have been numerous violations, and the violations began with the United States and Israel when on 28th of February, they lodged attacks to decapitate the leadership of Iran, which is a sovereign nation, just because of disagreements about nuclear matters and also issues about defense. This was quite unfortunate on both sides. And regarding the approach of the President of Kenya, he is meant to be advised by the Ministry of Foreign Affairs, also by the Office of the Attorney General, because the issues of international law in issue. But of course, the President, as the head of state, is meant to also be the leader of foreign policy of Kenya with the guidance of these various organs and institutions. He needs to be guided. And being a president doesn't mean you can't make mistakes, and sometimes he's made mistakes, and he needs to be guided on this matter.
Do you think this was a misstep? Because, you know, by dint of that statement, it would seem Kenya is throwing its lot with the United States and Israel in this matter.
The statement seemed to be Kenya throwing its lot with the Gulf countries, where Kenya has good relations with them. But for me, I felt there was an element of, allow me to say, very candidly, not just regarding the President of Kenya, but other heads of states across the world, a bit of cowardice, moral cowardice, in failing to call out the violations of international law when they are done by Western nations or Western allied nations like the United States and Israel. But people are very quick to call out violations of others. And the complicity also affects the media. You find even in the media reporting, when there is a strike by, for example, Iran, there is quick attribution that Iran has attacked and bombed such and such a place. When the strike is by, say, United States or Israel, the attribution is vague. They say a school has been hit in Iran and children have died. They use passive tense. So the moral cowardice is at several levels. And we need to start by calling out facts as we see them, right and wrong as we see it. If we do it at the international level, we'll have the courage to do it also at the domestic level. So it's very important to maintain that moral courage when we speak about these issues.
All right, let's talk about what's happening locally as well. That you say, calling out some of these issues that are taking place right now. There is a rule of law issue in the country, and this is with the respect to the process of becoming a Kenyan citizen and therefore acquiring a Kenyan passport. What's your reaction to the reports that we're seeing of persons of questionable character getting Kenyan passports? Senior counsel, assuming you're a fighter in Darfur and you have friends in Kenya, what's the right way of getting a passport?
If you're a fighter in Darfur, you are meant to apply, and most likely you will not be granted a passport because you have not qualified. Our citizenship and immigration law provides situations for those who are not Kenyan-born citizens by birth to apply and obtain passports by having been a resident in Kenya for at least 7 years continuously, by either a marriage where you are married to a Kenyan citizen and then you apply, Those are the methods that are recognized. Of course, there is a case of, in the constitution, of children of below 7 years who are found in the country and their origin is unknown. They are allowed to become Kenyan citizens, but that is what the constitution and the law provide. So if you are a fighter in Darfur, you don't meet any of those tests. If you want to come into Kenya as a refugee, that is a different issue. You go through United Nations Commission, High Commission for Refugees. You apply there, and if they allow you to become a refugee and they recommend you come to Kenya, that is well and good. So there are mechanisms in international law and also that correspond with our local law. But if you get involved in corruption, bribery, fraud, and you end up getting a Kenyan passport, that is very worrying at the security level, at the level of rule of law, at various levels it is, and even at the level of integrity and the fight against corruption. It is a very serious issue. It should be strongly investigated, and those who are responsible, of course, have to be brought to book.
And tonight, there remains silence since the story broke from both the Ministry of Interior, the Department of Immigration, about certain individuals acquiring Kenyan passports, some of them senior members of the Rapid Support Forces in Sudan, which has, of course, its roots in Janjaweed, and we know what happened in Darfur. You know, as a senior counsel, as president-elect of the Law Society of Kenya, what's your thought around how this matter came to light, how it's been handled, and how there continues to be silence at the highest levels of government?
I think it is a concern. Under Article 35 of the Constitution of Kenya, as well as the Access to Information Act, Kenyans can request and demand for information about this issue from the organs of state that are involved. So we need to do that, and the media need to continue playing their role very robustly of investigating the matter so that they can inform Kenyans. And once Kenyans know, the Kenyans who are public-spirited individuals can engage even in public interest litigation and other ways of putting pressure on the government so that this issue can be corrected and that it doesn't occur again.
I would like to focus on matters of access to justice. And one of the big words that has permeated our space now is the word juris pesa.
Yes.
There is allegations of bribery between the bar and the bench. What do you know, if anything, about this? How rampant is it? Are members of the Law Society of Kenya, actively bribing judges? Are judges soliciting bribes from members of the bar?
So I have just finished a period of campaign where I went around the country. I spoke to my members, lawyers, asking them what are their concerns about the legal profession, what are the issues they'd like to see us tackling and dealing with. And one of the issues that was talked about quite a bit was the question of corruption in the judiciary, whether it is in the court registries, these are judicial staff, or whether it is with magistrates and registrars, these ones we call judicial officers, or whether it is with judges. And corruption tends to be much more rampant at the lower levels, at the registries, then a bit less at the level of the judicial officers, a bit less at the level of the High Court judges, less at the level of the Court of Appeal. That is as far as I'm able to tell from the feedback from lawyers. That's one thing. So we also know that apart from the perception of corruption, one has to procure evidence and take it before the Judicial Service Commission when you have a concern against a judicial officer, if it is related to corruption or if it is related to incompetence or misconduct. All of those are reasons why a judge or judicial officer may be removed from office. And we know that the processes of the Judicial Service Commission have tended to be stopped or halted by cases that are filed by judges and judicial officers in the High Court, challenging the procedures of the Judicial Service Commission. Yeah. So that is also causing a concern, because the moment the Judicial Service Commission's powers and processes of investigating allegations of corruption or misconduct are interfered with repeatedly by High Court judges who receive petitions from those judges, judicial officers, or other interested parties bringing cases on behalf of them, then it sends a signal that there can be corruption or impunity within the judiciary, and that no recourse would be had, no effective recourse. So, of course, the judiciary, they also say that many times when people lose cases, they look for something to blame. And they may blame the judiciary even when there is no concrete evidence of corruption. And they are right in saying that if you're going to blame the judiciary, bring the evidence. The challenge is the processes where evidence can be brought are now being paralyzed from considering those situations. So then it becomes like an argument, bring the evidence, but the organs that are meant to process the evidence are being stopped, which is a problem. What I would say overall is that the perception is that the level of corruption, the judiciary, corruption is in all public sector organizations, but the level of corruption has been rising over the last few years, and we need to do something. This is the feedback I've got from my members. And to answer your last question, whether it is lawyers who are corrupting the judiciary, when they get corrupted, in the cases where there are allegations of corruption, some of them, the corruption may come from lawyers. Some it may come from the litigants themselves. Some it may come from paralegals or clerks and so on. So everyone engaging with the judiciary in different ways and situations may have access to situations where they can corrupt the judiciary. So when you are fighting corruption, you have to fight it at all levels. You have to fight the corruption within the judiciary. You have to fight amongst those who may be corrupting the judges and magistrates and judicial staff. You have to fight it by looking at the systems and seeing where are the systems failing in such a way that you need corruption to get services.
And let's talk about the system and how that works, because the manner in which one can raise a complaint about a judge or a judicial officer is through the JSC, right? Which would then, we know the process would form a tribunal, and that would then determine, the conduct of the person in question. So I don't want to be sub judice and speak about specific matters that are in court. But from a layman's perspective, explain this to us, senior counsel. You go to the JSC to complain about the conduct of a judge. The judge then goes to court to seek an injunction against the JSC from conducting it. And then the JSC now cannot continue with this probe, or it delays. So where is the challenge? Do we then not need the JSC? Are the judges then using the very courts in which they operate to frustrate the process of investigating their very own conduct?
My own honest view, and I have acted as a lawyer for the Judicial Service Commission in some cases, I've seen what is happening. My own honest view is that that is happening. There's frustration, deliberate frustration, and diminution or reduction of the role of JSC, contrary to what the framers of the Constitution intended. JSC, in certain court cases, has been reduced to the level of a local tribunal of one particular member of the legal profession who's sitting as a tribunal member. It has become like, say, a rent tribunal, a land tribunal, any kind of tribunal, and yet JSC has 5 judges, or 5 judges and judicial officers, 4 judges, Chief Justice, a judge from the Supreme Court, a judge from the Court of Appeal, a judge from the High Court. But when you find the way, and a magistrate from the magistracy, 2 senior lawyers there, the Attorney General there. So this is a very serious constitutional body. But the way its decisions are being aggressively supervised, superintended, and even stalled by the judiciary, it is an issue of concern. And of course, it's an issue where, when I become a president after being sworn in, I want to address. And one of the ways of addressing it is by bringing light to the problem. Because there's this saying that democracy dies in darkness. Integrity also suffers in darkness. So the moment you shine light onto these cases, then we hope that there'll be greater sense of judicial responsibility and accountability in those cases where the High Court, exercising its supervisory powers to oversight all bodies and tribunals, reviews the proceedings of JSC. It doesn't mean that JSC can never be reviewed by a judge, but there has to be a measure of respect in the process. There has to be a measure in which the judges recognize that JSC is just a preparatory stage, because if they find that a complaint is merited on a basic level, they take it to a tribunal where there are full fair hearing rights given to the judge or magistrate, as the case may be. But if you frustrate even the investigative process of JSC, then you are undermining judicial accountability, which is one of the two values in the Constitution, judicial independence and accountability, that are important for the judiciary.
So let's talk about, there have been public accusations against very senior members of the judiciary, particularly those of the Supreme Court, by fellow senior counsel. Charles, and then we suddenly see a deal is brokered or some sort of agreement. What are we to make of public accusations, very direct ones, of bribery, of misconduct of Supreme Court judges, followed by a private settlement of the matter and a complete change of tone? SC, aren't allegations of bribery a public interest issue? Or was this a matter of just, egos and playing this out in the public domain?
First, let me clarify. What I understood was that there was an agreement by the Chief Justice and two senior counsel who had made a number of public complaints to collaborate in ensuring that complaints or issues of judicial corruption are processed effectively through the mechanisms that are available. So it was not an agreement, a compromise to cover up judicial corruption, but actually it was a compromise to ensure that the processes work so that any judicial corruption instances are brought to light and dealt with.
Yeah, but in the manner in which that was done, because there was lots of dirty linen being washed in public, and I mean, there was some, it was very heated between both sides. Now, as members of the public, who are then watching senior members of the bar and of the bench trade these accusations, and then now it's, okay, let's hold hands and sing Kumbaya and everything is well. Where does that leave members of the public for whom these allegations that are made in public maybe start to make them doubt, the sort of justice they would get at such high levels? And then now suddenly the matter is quiet and being handled in the right way. Could there have been a different way to have handled this in the beginning? Because certainly from some quarters, it would look like these were just personal grievances.
For me, what I would say, as matters of principle, number one, when there are serious instances of corruption, actual or alleged, it is good that these matters are brought to light, because light is a disinfectant that cleans these kind of situations. Number two, when there are serious allegations of corruption, whether relating to the judiciary, it is good that evidence is collated and then it is processed through the organs that process these allegations. Number three, that even the accused, the accused, the judges or judicial officers have a right to due process and have a right to also ensure that they have an opportunity to defend themselves, and that allegations that are made on the basis of, you could say, a good foundation of evidence or accusation. So those three principles are important. I'll not say that keep quiet about issues of judicial corruption. I'll not say make allegations if they are not founded. I'll say both you need to speak out. You need to ensure that you secure the dignity of the judiciary, because it's one of the ways in which the judiciary is able to have authority to deal with ordinary matters. And you need to ensure you process complaints through the mechanism. So all those mechanisms, all those things are required. And when you're doing that, when you're fighting corruption, there may be an instance where there is appearance of corruption, but after investigation it is found maybe not to have been founded. But if you silence those who want to fight corruption from raising the grievance, then you have darkness, and corruption thrives in darkness. So we need light, but it has to be light that is disinfecting spaces, not light that is poisoning.
And on this matter of, access to justice, of which that was a part, what's your appreciation of this principle, particularly for those who go to the courts seeking some type of justice? Do you think that this principle is actually accessible to all Kenyans equally and affordably?
No, there are many challenges of access to justice. In fact, the big problem we are having in Kenya now is a mismatch. There is a lot of demand for justice from Kenyans, and then there are many lawyers who are coming into the profession. The lawyers are not finding enough work. The Kenyans are not finding enough opportunity for access to justice, so there's a bottleneck somewhere. We are getting more lawyers who are ready to assist the process of access to justice, and they're not getting work. We are finding more Kenyans who need access to justice. I'll give you one example. When a few years back, Parliament passed the Small Claims Court Act to allow claims of below 1 million shillings to be handled within 60 days, and these claims started being filed in the courts, they became so many. Tens of thousands are being filed every year. And even as the judiciary is recruiting more and more magistrates and adjudicators to deal with these cases, they can't cope. So you can see clearly, the moment you come up with a system that's meant to be efficient, 60 days to get justice, there's a lot of thirst and kind of like demand for justice. And yet, there are many lawyers available, but they don't have work. So one of the things I want to do as president-elect of the Law Society, once I take office, is to address these bottlenecks and to see how we can deal with the access to justice problem. It's not just a Kenyan problem, it's a global problem. Many people have written about it and given recommendations of how to address it.
From ordinary Kenyans' perspective, one of those bottlenecks is actually the cost of seeking and getting justice.
Yes.
You lawyers don't come cheap. We've seen some fee notes that are eye-watering for lawyers.
Yes.
But, completely crippling for ordinary Kenyans who want to seek justice. And so to the extent that it, becomes almost impossible for persons seeking the services of, the many lawyers that you say are looking for work. An employed man on the streets cannot possibly afford the advocate's remuneration rates, neither can a peasant for that matter. What are you going to do about these inequalities that just simply speak to the fact that advocate and legal services are, quite frankly, unaffordable to a big number of Kenyans?
I think one challenge we have is a challenge of poverty in the country, which means that all manner of professional services, whether it is health services in our hospitals, whether it is education at higher level, whether it is you want to build a house, you need an architect, all manner of professional services are going out of reach of Kenyans. And this is a challenge that all professionals are facing. So we have to look for solutions to try and deal with that deficit in terms of the gap between demand and supply based on affordability. In the medical sector, one of the ways they've addressed it is through medical insurance. But still, there are many Kenyans who can't afford the medical insurance. When they get sick, it's always harambe, because you have to fundraise for the sick person. So the lawyer is also a professional, like the doctor, who has been trained and who needs to have a life with, to carry out the profession with dignity. The same way medical care is expensive, even legal care is expensive. Actually, when you do a benchmarking of legal services in Kenya, in Uganda, in South Africa, you'll find that Kenya, in terms of comparing to the GDP, is actually quite low. The cost of legal services in Kenya.
But still, Senior Counsel, Kenyans cannot afford, even if you're to look at it comparatively.
I'm just telling you, for example, how many Kenyans can afford to buy newspaper every day? And that is media. So I'm telling you, even your own profession, the media profession, apart from television, which is supported by advertisers. How many can afford the print media every day?
Okay, so we're talking about the legal profession.
So what I'm trying to say is that all professions have that challenge because of widespread poverty, and all of them have to find solutions. One of the solutions in the legal profession, of course, is legal aid for those who cannot afford. There's even a national legal aid service that has been set up by the government. It requires more funding so that they can assist the Kenyans who can't afford. But I would say that 90% of the cases where Kenyans need legal services, they can afford the legal services. They are the special cases, 5 to 10%, where they need assistance.
So 90% of the legal services that are accorded to Kenyans are affordable for them, you say?
I know that as a provider of legal services, 90% of the people who come to lawyers are affording our legal services. I know that as a fact. And I know that it is probably 5 to 10% because every lawyer does a bit of pro bono legal work. I know that is the fact. But I also know that in the same way, some Kenyans are not able to afford good quality care in hospitals. Some Kenyans are not able to afford quality legal care.
Services are affordable to a large part of Kenyans.
Of course. That is why so many lawyers, 18,000, are in employment. They're offering services, paid services to Kenyans who are paying them. So that is why there are 18,000.
All right, so the bottleneck is 18,000 out of 26,000?
No.
Wait, and out of how many are out there looking for work? So your challenge here is not with the cost of legal services?
No, when you talk about access to justice, there are two aspects of access to justice.
Yeah.
One of them is the cost, and it's a global issue. And of course, one of the ways of dealing with the cost, if it is in medical care, is insurance. If it is a case of legal service, you also need to deal with it.
So I just want to understand.
And then
let's just answer this very directly.
Yes.
According to you, one of the challenges with respect to access to justice, affordability of legal services is not one of the challenges.
Of course it is one of the challenges.
But you've just said 90% of
No,
of
it's not a challenge to everyone. It's not a challenge to everyone. Like you, Yvonne, if you needed legal services, I know you'll afford my legal services. But there will be someone else who will not.
Okay.
Yes.
So you just said that 90% of the Kenyans can afford legal services.
What I've
90% is a big number, isn't it?
What I've said is that 90% of the people who are seeking legal services from professionals are able to afford.
Okay.
But then they can afford at different levels.
Fine. On that metric alone then, the issue of affordability of legal services isn't a challenge.
No, of course it is. Of course it is. Because, for example...
If we use that 90%...
I'll give you an example. You may say that 90% of Kenyans can afford to get 2 meals a day. But then the question is, what is the quality of the meal? Maybe they need a third meal. So the question of affordability also is a question of degree. You can afford some level of legal services, but you might have wanted to have much more legal service than what you've afforded. And this is true of all professions, Yvonne. Even the media. All right. There are some Kenyans who can listen to you on Citizen TV, but they are not able to buy a newspaper. You get what I'm saying?
I understand that. We've given that example. I'd like us, before we get to our viewer questions, to just ask you about this that's happening on the political front, and that is the prospect of early campaigns, as it were. The IEBC has not even officially declared the official campaign period. Do you see this, is this an area of concern for you as president-elect? And is it a failure on the election legal framework where we have basically politicians campaigning every day, right from the president to the last MCA aspirant? They're on the campaign trail every single day, as recently as today.
My answer will be yes and no. First of all, I'll say no because Kenyans have political rights under Article 38 of the Constitution. There's freedom of expression under Article 33, freedom of association, Article 36, freedom of assembly, Article 37. So they're entitled to exercise these rights all the time, not just 3 months before the elections. They're entitled to discuss political issues. Governance includes politics. Politics is not just when you are voting for the next president or MP. Even when laws are being passed, there is a process of politics. Politics is the art of influencing others, of engaging people. So in that sense, it is good when there's robust politics that contributes to governance so that you listen to the views of the people. But I also said, yes, it's a concern, because if you focus so much on politics and not on governance, especially when you are in government, then it means that you are not giving value to Kenyans who voted you in office. You're not giving a focus for implementation of your manifesto. You are distracted from governing Kenyans. So it's a balance. So I don't think we should just criticize politics because it has happened 1 year after the election. Even 6 months after the election, Kenyans need to engage in politics regarding the budget, the finance bill, and all those other things. That's part of politics, so even development. Why have you not built a road in my constituency? So you engage on those issues, but it is development oriented, it is oriented towards a good governance. That kind of politics, you should engage in it all the time. But now the competitive politics,
the campaign.
The competitive politics where you are running for a seat, then that one I say that if you're in opposition, then you're entitled to do it all the time because you don't have other platforms to engage Kenyans. But if you're in government, then you already have platforms to engage Kenyans on issues of development. You need to balance very well between how much time you're spending politicking and doing development. And then, of course, there's a concern. If you're a civil servant or a state officer under the Constitution, you're not meant to be engaging in partisan politics. So if those people are engaging in partisan politics, then they are violating constitutional principles.
Let's take some questions from our viewers now. Are we ready with those? Here's one from Tony Cheese. Please ask the LSK president how he intends to rein in on fraudulent lawyers who've partnered with police to defraud insurers and insured by submitting fraudulent claims and cases in court. PSV accidents are most affected.
So first, as I answer the question, let me say that we also have concerns as lawyers that many judgments and decrees in personal injury cases, which are meant to be covered by insurance companies, are not being covered by those companies. So there's also a concern with the state of the insurance sector. But it is true that there are instances where some lawyers may engage in collusion that amounts to fraud. How do you deal with that situation? On a case-by-case basis. As I was talking before, we have mechanisms for discipline, like the Advocates Disciplinary Tribunal, the Advocates Complaints Commission, and you can even lodge a case in court if you feel there has been fraud. But if there is a court judgment, which means a judicial officer has tested the evidence and found that this was a case deserving of compensation, then surely there should be settlement, quick settlement of such claims.
Let's take another one. This one is from Fred Obachi Machoka. Is it true that the LSK president doesn't earn any wages? If so, how does he or she operate without finances?
Yes, so that's a good question. The position of the president of the Law Society is non-executive. You are the chair of a board. It's like the chair of the board of ABSA or Safaricom. Is not an executive position. So you earn sitting allowances when you sit. But of course, the president does so much more that, than the sitting for a meeting, which may happen once or twice a month. And so it requires the president to volunteer their time and resources. But they also need to concurrently keep running their legal job. Like in my case, I run a law firm. I'm a managing partner in my law firm. That is where I earn my wages. Even when I'm president of the Law Society of Kenya, that is where I have to earn my daily bread. So the work that we do for the legal profession, the Law Society of Kenya, is a big chunk of it on volunteer basis. And Kenyans need to realize this. It's not a full-time job. It's part-time. It is not paying you a wage. You don't get a salary. The salary still comes from the job you are doing before you became president. You may get a few allowances when you sit, but they are grossly inadequate compared to the amount of work you need to do. But we do it as a way of giving back to the profession, because we cultivate this culture in the legal profession that everyone to do something for the benefit of the profession. We call it pro bono, or for the good of society, for good. And some call it pro deo, for God. So that is what we are doing.
Okay. Another one? Let's go to the next one. This is from Mukhtar Khalif in Wajir. As the current president, there are a lot of lawyers graduated from various universities but can't practice because they didn't go to the Kenya School of Law due to lack of money. How can you help such lawyers be admitted to the School of Law later to pay their dues when they practice? Is that possible?
Of course it is possible, and the situation is actually quite unfortunate. Of the dozens of lawyers, maybe even hundreds, who have graduated from law school, they are eligible for admission to Kenya School of Law. In fact, they've been admitted, but they are not able to take up the course because of lack of funds. And it is affecting many poor Kenyans, families where they have educated their children through a lot of struggle up to university level. They have benefited from HELB or Higher Education Loans Board loans in university. Then when they go to Kenya School of Law, they are not supported. There are a number of strategies that can be implemented. One of them, of course, being to try and get HELB, Higher Education Loans Board, to get funding to give loans to such students that can be paid after they are admitted to the bar. And secondly, we can also use other providers of financial services, LSK, SACCO, and others who can give packages. And if we enter into collaborative agreements with the Law Society of Kenya, probably some of the students will be able to get funding. Right now, they are forced to do harambees, and if they can't afford, they have to wait for a few years while they earn money from other jobs until they save enough to now go to Kenya School of Law.
All right, let's take, I think, two last ones. This is from Guda Experience. Ask the LSK president, how does he plan to ensure that court orders are respected and enforced in Kenya, especially when government institutions or powerful individuals ignore them?
This issue of impunity is one of the big concerns that I have and the Law Society of Kenya has. And there are various strategies we are going to put in place, including one that I mentioned the other day, where we are going to push for the creation of a judiciary police enforcement unit that can assist with the enforcement of court orders, coordinate with the General Police Service, and be under the guidance of the judiciary so that court orders are obeyed. And this includes court orders that are being disobeyed even by members of the public, by private sector as well as public sector. And then, of course, the Law Society of Kenya and other litigants have to be able to use court processes to get orders of mandamus, which are orders compelling public officers to work in a certain way, and orders of contempt, so that if they don't act according to the court orders, they are found in contempt and they can be imprisoned. They can be fined. So there are ways in which you target the specific officer who's in contempt of the court order. And these processes, these judicial processes of enforcement of court orders need to be made faster and more efficient.
Quick last one from, this is Bright Fame. Does LSK believe the judiciary is fully independent, or is it under subtle pressure? I think the second question, you'd already answered that. So maybe you could answer the first one. Is the judiciary fully independent? Of
course, we have concerns about independence of the judiciary. I've talked at length about accountability. And now it is a good opportunity to talk about independence. Independence of the judiciary is various kinds. There's financial independence. The judiciary is not getting adequate budget. There was a creation of a judiciary fund, which was meant to ensure that the judiciary is not susceptible to executive pressure. It's never been really operationalized. There is decisional independence of judges. They may be influenced, maybe even by fellow judges, by lawyers, by members of the public, members of the executive. That's a concern. There is institutional independence of the judiciary that also has to be promoted through various means. Sometimes even I'm concerned, even judicial transfer of a judge from one place to the other, sometimes can be an instrument that interferes with decisional independence. So as the Law Society of Kenya under my leadership, we will be fighting to champion both judicial independence that's very robust and also judicial accountability. The two of them must go hand in hand.
As we close, do you think, what do you think is one of the key competencies of being president of the Law Society of Kenya? Is it dancing moves? Because I'm not sure what this says about it. But let's look at the tweet first. I think there is one on that. Okay. This one from Noah Kiptalia. Congrats on the win, SC. A couple of burning questions. Is it true you coined Katiba Day before the government took it over?
The truth is that I was in the meeting, Kanjama Charles, with Nelson Harvey, who was the president of the Law Society of Kenya, and one of my colleagues, Vincent Kimosop, when we discussed about Katiba Day and came up with the name Katiba Day and said we are going to commemorate it on 27th of August every year. So I was one of those people involved in coining Katiba Day, together with my KCPF secretary, Vincent Kimosop, and the then LSK president, Nelson Harvey. And this was in 2020, August.
Right, and the last question on that one was your dance moves. Do you think your dance moves make you qualified for the LSK president? Maybe for context, this is what we mean. Okay, SC, what is this? What are you doing? What's this on this? What are you doing?
So let me put it this way. During the 3 months of the campaign, we were dancing away in the various events. Because you have to be approachable and you have to be with the people.
Right.
And
do you think this makes you approachable?
No. I can tell you there were many lawyers who are very delighted with me joining them in the dance. Maybe you've seen one clip of a dance, but I was dancing for 3 months with a lot of positive appreciation. In fact, I can tell you
Shall we say you were moving corruption to the side? Because
no.
There's question about what
what we can do, Yvonne, is when we finish here, we go to the dance floor and we do a dance-off and we see who will dance better. I can tell you that the young lawyers were very delighted that I was able to join them in the dancing, even the mid-bar and the senior bar.
Right.
And of course, dancing is part of our culture as Kenyans. Yes.
Okay. Maybe senior counsel, respectfully, you should stick to litigating matters. This, anyway, I'll say very little about your dance moves. I'm not sure mine are any better, but...
No. I think you may have seen one small clip. I've been dancing for 3 months with a lot of positive appreciation of members. And you know, when you're dancing, dancing is about expression of your feeling, expression of your sentiment.
Right.
Yeah, so you flow.
So there's a sentiment here. Yeah?
Of course, there are many sentiments there. And it's about enjoyment. But,
indeed.
And we must encourage Kenyans to dance more. Yes.
Okay, all right. Yeah, maybe they will have their own moves. I'm not sure that they will be copying these. Thank you so much, Senior Counsel Charles Kanjama, for joining us here on the program today. President-elect of the Law Society of Kenya, wishing you the very best in your single 2-year term.
Yes, indeed.
Perhaps you are the ones who coined
one
now
term.
Popular phrase.
Yes, one term in the Law Society of Kenya is by law. And I look forward to serving Kenyans, to serving the members of the legal profession, promoting rule of law, access to justice, a dignified legal profession where the lawyers can serve with dignity as they're serving Kenyans. All that we anticipate to do, not alone, because I believe that leadership is about being a choir master or a conductor of an orchestra. You move with people, you work with people. And it's only when the people are with you and you're moving the same direction that you can really have impact. That is what we hope to have over the next 2 years. Thank
you very much for your time. I wish you the very best in your mandate once you take office at the end of the month of March 2026. Senior Counsel Charles Kanjama, President-elect of the Law Society of Kenya, on The Explainer tonight. Thank you for watching. Have a good night. Thank you.